Picture this. You promise a friend a cut of a massive settlement you're expecting from a lawsuit.
Right. Happens all the time.
Yeah, maybe you even write them an IOU on a napkin just to cover a debt you owe them. But months later, when that glorious check actually clears the bank and the cash is sitting right there in front of you, you suddenly don't feel like sharing.
Oh, absolutely. It's tough to let it go.
And it really is a very human temptation, right? Like, why give away the money when you finally have it in your hands? But legally, giving into that temptation creates a spectacular multi-party collision. All right, let's unpack this. Today, our mission in this deep dive is to dissect the exact mechanics of assigning contract rights. We're looking at what happens when three distinct people collide: the assigner who makes the promise, the assignee who expects the money, and the obligor, the person who is actually holding the bag of funds.
What's fascinating here is how the law imposes a rigid, almost mathematical structure onto what feels like a very messy, emotional human dispute.
Right.
To truly understand this dynamic, we have to examine the legal doctrine of assignment. We're going to trace the analytical path of how a valid assignment is formed under the law, and then, well, we'll look at the severe, almost strict liability consequences for an obligor who decides to simply ignore that assignment.
So we're essentially talking about transferring an intangible right. It's almost like handing over an invisible asset.
That's a great way to put it.
Like, you can't hold a future lawsuit settlement in your hand, but you can apparently give it away. So let's start with the foundation. How exactly does an individual legally assign a right to someone else?
Well, under the foundational principles of Maine law, and this draws heavily on historical cases like Shiro versus Drew and Palmer versus Palmer, the general rule for the validity of an assignment requires three specific elements to be met.
Okay, 3 elements. What are there?
First, there must be a clear manifestation of intent by the assigner to relinquish the right to the assignee. Second, the assigner must not retain any control over the right assigned, nor can they retain any power of revocation.
They have to fully, completely let go.
Exactly. Total relinquishment. And third, adequate notice must be provided to the obligor.
Okay, intent. A total lack of control by the person giving it away, and notice to the person holding the money. But I want to pause on that third element, notice. What actually happens the exact second that notice is achieved?
That's a huge shift.
Because it sounds like you're just, sending an email or making a phone call, but legally it seems like something much heavier is happening.
It is. This raises an important question about the nature of the funds. The moment the obligor receives that notice, the legal status of the money fundamentally changes. The funds are immediately impounded.
Impounded.
Yeah, they are impressed with what the law calls a trust.
Impressed with the trust. What does that actually look like in practice?
Think of it like an invisible escrow account dropping out of the sky.
Oh, wow.
The very second the obligor, let's say it's a lawyer holding a settlement, reads that notice, a legal wall slams down. From that second forward, the obligor is no longer holding the money for the original creditor, their client.
Wait, really?
Really, the legal DNA of those funds has changed. They are now legally mandated to hold it for the substituted creditor, the assignee.
Wait, so the obligor doesn't even have to agree to it. The trust just magically snaps into existence the moment they're made aware of it.
Pretty much, Ev.
That feels like an absolute trap for the unwary. To see how strict this gets, let's analyze Herzog versus Irace. First, what are the legally dispositive facts?
The facts here are a perfect storm of bad luck and binding paperwork. We have a man named Gary Jones. He is our assigner.
Okay.
Jones was injured in a motorcycle accident and hired 2 attorneys, Irace and Lowry, to sue for personal injury. Those attorneys are our obligors. They're the ones who will eventually hold the settlement money.
Got it.
Sometime later, in completely unrelated incidents, Jones dislocated his shoulder twice. It was severe, and he desperately needed surgery.
And let me guess, because he was already dealing with the aftermath of a motorcycle crash, he didn't have the cash on hand to pay for shoulder surgery.
Exactly. So he went to Dr. John Herzog, who becomes our assignee. Because Jones couldn't pay up front, he signed a letter on Dr. Herzog's own letterhead.
Ah, paperwork.
Yep. The letter requested that payment for the shoulder surgery be made directly to Dr. Herzog out of the future settlement from the pending motorcycle accident case. Dr. Herzog then took that letter and officially notified the attorneys Irace and Lowry.
Got it. So it's a classic IOU, but it's specifically backed by the proceeds of a future lawsuit.
Precisely. So Dr. Herzog performed the surgery, which was successful, and he continued to treat Jones for a year.
So the doctor did his part.
He absolutely did. Fast forward to May 1989. Jones finally gets a $20,000 settlement from his motorcycle case. The money is sitting right there in the lawyer's trust account.
And here comes the temptation.
You know it.
Yeah.
Suddenly, Jones instructs his attorneys not to pay Dr. Herzog. He claims he'll handle the medical payment himself.
Oh.
The attorneys, trying to follow their client's explicit instructions, issue a check to Jones for over $10,000 and disperse the rest to other creditors. Jones does eventually write a check to Dr. Herzog, but it bounces due to insufficient funds.
Ouch. So the doctor gets nothing.
Nothing. So Dr. Herzog is left completely unpaid, and he turns around and sues the attorneys directly.
And what was the core legal issue?
The precise issue the court had to resolve was this. Did the client's letter constitute a valid, enforceable assignment of settlement proceeds that required the attorneys to pay the doctor despite the client's subsequent revocation?
Right.
And further, did enforcing this assignment against the attorneys violate their ethical obligations to follow their own client's instructions?
This is such a fascinating bind for the lawyers. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the black-letter rule governing the equitable assignment of future pending litigation proceeds.
Okay, let's translate that into normal human English. We're basically talking about legally handing over your slice of a lawsuit before the lawsuit is even finished.
Exactly. And this rule states that an assignment is valid and enforceable directly against an obliger if three elements are met.
Oh.
First, there must be a clear manifestation of intent to transfer the right to the assignee. Second, there must be no retention of control or power of revocation by the assigner. And third, there must be notice given to the obliger.
Just like the general rule we discussed earlier.
Right, but the court also noted a vital sub-rule from an older case, McClellan versus Walker. This clarifies that an equitable assignment does not need to transfer the entire future right. It can be a partial assignment. You can carve off just a piece of the pie.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, manifestation of intent?
Well, the sub-issue here is whether the June 14 letter manifested a clear intent to transfer the right.
Because I know there was big fight over the specific words Jones used.
There was. The sub-rule dictates that the language of the document must indicate an actual transfer of rights, not just a casual wish or a polite suggestion. In its application, the attorneys fought back hard. They argued the letter was invalid because Jones used the word request, as in, I request that payment be made.
Right.
They argued a request is just asking nicely. It is not a permanent, legally binding transfer.
I have to say, I'm with the lawyers on this one. I request sounds incredibly soft. I mean, if I request a window seat on an airplane, I am not drafting a binding contract. I'm just stating a preference. Why isn't it required to say, I hereby permanently transfer and assign?
Because the law looks at the reality of the mechanism, not just the magic words.
Oh, interesting.
Yeah, the court rejected the lawyer's argument by looking at the broader context of the transaction. Jones wasn't just casually asking for a favor. This letter was executed in consideration for necessary, expensive medical services rendered by Dr. Herzog.
Oh, so the fact that it was for actual surgery matters?
Exactly. Given the medical context and the reality that Herzog was relying on this exact document to perform surgery, the word request functioned as a directive. It did not undermine the intent to complete a valid assignment.
Wow.
Therefore, the court's conclusion was that the first element was successfully met. The intent was clear based on the context of the exchange.
Understood. The context overrides the soft language. Now, what about the second element, no retention of control?
The sub-issue here is, did Jones retain any power to revoke the assignment or control the funds? The governing sub-rule dictates that an assignment is completely invalid if the assigner keeps strings attached.
So any strings at all?
Any strings. If you hold onto a power to cancel the deal or redirect the money later, it is not an assignment. It's just a temporary illusion.
So why can't I just write, pay the doctor, unless I end up needing the money for rent? Why does the law demand total relinquishment?
If we connect this to the bigger picture, it is about preventing chaos in commerce. I mean, if people could cancel IOUs at will, no one would ever rely on them. Dr. Herzog would never perform the surgery if Jones had a legally recognized escape hatch.
That makes sense.
Right. So when applying the facts, the court examined the June 14 letter again. The court found absolutely no indication in the text or in the surrounding circumstances that Jones attempted to retain any control over the specific funds.
So he didn't write any exceptions in there?
None. He didn't say, pay the doctor unless I tell you otherwise. He simply assigned it. Thus, the conclusion was that element 2 is met. Jones retained no control.
He let go of the steering wheel completely. And what about the third element? Notice to the obligor.
For this element, the sub-issue is, did the attorneys have adequate notice, and what is the legal effect of that notice?
We talked about that invisible escrow account earlier.
Exactly. The sub-rule, drawing on the foundational Palmer case, is that once an obligor has notice of the assignment, the assigned fund is officially impressed with a trust. It is impounded for the assignee. If the obligor pays the assigner after receiving notice, they do so at their own peril.
Okay, so how did the court confirm the lawyers were prepped by it?
Well, applying the facts, the court noted that Dr. Herzog didn't just casually mention it. He explicitly notified the law firm. An employee of the firm actually acknowledged the assignment.
Ah, so they definitely knew.
Yes, and crucially, the firm ultimately held ample funds, a $20,000 settlement, which was more than enough to cover Dr. Herzog's reasonable medical bills, with money still left over for Jones.
So there was no shortage of cash.
Right. Because the firm had unquestionable notice and sufficient funds, the conclusion was that the third element was easily met.
Here's where it gets really interesting to me, and frankly where I need to push back on the fairness of all this. These obligors aren't just random banks holding cash. They are lawyers. Doesn't a lawyer have a strict ethical obligation to follow their client's instructions under the main bar rules?
That's a great point.
Like, if my lawyer doesn't do what I tell them to do with my own settlement money, shouldn't they be disbarred? It feels like the court is putting these attorneys in an impossible catch-22.
That is exactly the defense Irace and Lowry attempted to use, and it is a very clever one. They tried to pit legal ethics against contract law. So let's run an analysis on this specific ethical defense.
Okay, let's hear it.
The sub-issue is, does enforcing this assignment against the attorneys violate Main Bar Rule 3.6? The sub-rule, found right in the bar rules, states that lawyers must promptly pay or deliver to the client funds which the client is entitled to receive.
Right, which the client is entitled to receive. So the lawyers argued, hey, Jones is our client, it's his motorcycle settlement, he literally told us to give it to him, so we are ethically bound by the bar rules to hand it over. How is that wrong?
I mean, it sounds bulletproof until you look at the mechanism of the assignment we just built.
Yeah.
Here is how the court applied the law to shatter that defense. You have to hyper-focus on the phrase entitled to receive.
Okay.
Because Jones had already executed a perfectly valid assignment to Dr. Herzog back in June, Jones legally transferred his right to that specific portion of the settlement. The legal DNA of the money changed. Therefore, when the $20,000 came in, Jones was no longer entitled to receive those specific assigned funds.
So the bar rule didn't even apply to that portion of the money anymore. The lawyer isn't stealing from the client. The client is trying to use the lawyer to steal from the doctor.
Exactly. The lawyers had no ethical obligation and no contractual obligation to honor a client's instruction to disregard a valid assignment. The client cannot order his lawyer to claw back money he already legally gave away.
Yeah. Wow.
So the conclusion on this defense is that the ethical argument completely fails. The rule only protects funds the client actually owns.
And after analyzing all the elements and knocking down the ethical defense, what was the court's final conclusion?
The ultimate holding was that the district court's judgment was affirmed. The assignment was valid, and it was enforceable directly against the attorneys, Irace and Lowry.
So they were personally on the hook.
Yes. By paying Jones instead of Dr. Herzog after receiving notice, the attorneys breached the assignment. They ignored the invisible escrow account, they paid out at their own peril, and as a result, the attorneys themselves were held personally financially liable to Dr. Herzog out of their own pockets.
Wow. So the lawyers had to pay the doctor's bill with their own money just because they listened to their client instead of following the strict mechanics of contract law.
It's a brutal, expensive lesson.
Absolutely brutal. I really want to make sure you, our listener, permanently remember these strict rules, especially the interplay between intent, control, and notice. So I am going to propose a rather visceral hypothetical to test the boundaries here.
Oh, I'm ready. Lay it on me.
Imagine you, the listener, are injured in a horrific, incredibly messy septic tank explosion.
Oh, lovely.
It is a total disaster. You hire a lawyer to sue the negligent septic company. Meanwhile, your house is coated floor to ceiling in biohazardous sludge.
Gross.
Right. You hire an extreme cleaning crew to scrub the sludge out of your living room. But you're broke. Unable to pay their exorbitant fee up front, you scrawl a message on a piece of yellow biohazard tape with a Sharpie. You write, I permanently give the sludge cleaners $5,000 from my septic lawsuit.
Okay, biohazard tape contract.
Yep. You peel off the tape and hand it directly to your lawyer. Months later, the lawyer wins $50,000 for you. You look at all that cash and tell the lawyer, you know what? Never mind. I want all the cash. Don't pay the cleaners. They did a terrible job anyway.
That is a fantastic, if slightly stomach-churning hypothetical. Let's break it down using the exact rules we just extracted from Herzog. First, did the biohazard tape show a clear manifestation of intent?
To give.
Yes, you wrote permanently give,
Yeah.
which is an even stronger transfer of rights than the word request used in the Herzog case.
Right.
Second, did you retain control or a power to revoke? No. The tape didn't say give them $5,000 unless I decide they did a bad job. You completely relinquished control over that specific $5,000.
And the third element, notice.
Notice is perfectly satisfied because you handed the biohazard tape directly to your lawyer, the obligator. The very moment your lawyer read that tape, that $5,000 was legally impounded. It was impressed with a trust.
Just like the invisible escrow account.
Exactly. If your lawyer listens to your new instructions, hands you the full $50,000, and ignores the sludge cleaners, the lawyer has breached that trust. Under the law, the lawyer is now personally on the hook to pay the cleaners $5,000 out of their own pocket, just like Irace and Lowry.
So the lawyer cannot hide behind, but my client told me to. Even if the, quote-unquote contract was written on biohazard tape in Sharpie.
No, they cannot.
Yeah.
Because the law prioritizes stability. It protects the assignee's reliance, the cleaners who scrubbed your house, based on a promise over the assigner's fleeting whims, buyer's remorse, or sunny greed.
That is incredibly clear and honestly a little terrifying if you ever find yourself holding someone else's money. To wrap this all up, could you distill everything we've discussed into a concrete, usable framework? I want our listener to have a reliable mental checklist they can use to spot these exact issues in high-pressure situations or, if they're staring down a brutal law school exam.
Absolutely. If you are analyzing a potential assignment of rights, you need to use this strict 6-step diagnostic checklist synthesizing the Herzog rules. Step 1, identify the parties. Clearly map out who is the assigner giving up the right, who is the assignee receiving the right, and who is the obligor holding the bag of funds.
Right, get the players straight first.
Exactly. Then step 2, check for intent. Did the assigner use language showing a clear transfer of the right? Remember the Herzog nuance. Even a softer word like request works if the surrounding context proves a transfer was intended for services rendered.
Like the surgery context overriding the polite wording.
Precisely. Step 3, check for control. Did the assigner retain any strings attached? If they kept the power to revoke the assignment or change the destination of the funds, it is a fatal flaw. It is not a valid assignment.
It's all or nothing.
All or nothing. Then step 4, verify notice. Was the obligor informed? Remember the critical trap here, the obligor does not have to accept, agree, or sign off on the assignment. Mere notice is enough to instantly create the trust and trap the funds.
The wall slams down.
It really does. Step 5, assess the payout. Look at what the obligor actually did. Did the obligor pay the assigner after receiving notice? If they did, they violated the trust. They pay at their own peril and are strictly liable to the assignee.
And fine.
Step 6, defeat the ethical defense. If the obligor is an attorney arguing they had to follow their client's instructions, you strike that down. Remember that an attorney's duty to hand over client funds only applies to funds the client is legally entitled to receive. Once assigned, the client's entitlement vanishes completely.
So what does this all mean? It means the flow of money and rights in our world is governed by invisible yet incredibly rigid tripwires. It leaves you pondering a pretty heavy question. If you are ever holding money, property, or assets for someone else, how rigorously must you investigate third-party claims before handing that money over? Because ignorance, or just blindly trusting the person who gave you the asset, might end up costing you everything out of your own pocket. I challenge you to look at every contract, every agreement, or even just a casual IOU in your life right now and ask, who really controls this right? Because as we saw today, once you promise someone money from a future pot and they rely on it, changing your mind when the check clears isn't just bad manners. It alters the legal reality of everyone involved. Keep questioning, keep exploring, and we'll see you on the next deep dive.